lost your audience, but
I'm accustomed to that.
all right. Floor is yours.
Thank you.
Good morning.
I've often said I always feel like a lawyer when I'm here, so glad to be here in front of the panel. There's a lot going on this case, and depending upon the court's...
Do you want to reserve time for rebuttal?
I'm so sorry. Tim Harvey from the Montgomery County Bar. Pleasure to be here before the panel, and I would like to reserve 5 minutes.
5 minutes, yes, sir.
There's a lot going on in this case, and I'm not sure where the panel's questions, if any, may focus. So I want to try to address them all in my first 10 minutes. But this is a question of a summary judgment grant which dismissed all claims against the defendants, and there were 2 of them. Lee Masonry, a local Hopkinsville seller of bricks and mortar and maybe lumber and other things, and a manufacturer of bricks called Acme Brick. So my client, Billy Hughes and Tammy Hughes, are a married couple, and this is their residence they were building. Mr. Hughes is a contractor himself, been building homes and commercial buildings for years. He ordered Acme Brick from Lee Masonry. At some point, we've all had those phone calls from clients, oh, the brick doesn't look like it did on the sample. Well, that's not what's at issue here. There's apparently no dispute that somehow the brick that was delivered had a few cubes or pieces that did look remarkably different. I think that they can be described as having more sand on them in some cases. So we're not dealing with all the colors wrong as much as the color was inconsistent. So when that was recognized, Mr. Hughes called Lee Masonry. They sent a man out who was named Mr. Sanders. Mr. Sanders, and it's cited in, all this is cited in the record. Mr. Sanders says, I can see what you're talking about. This brick's different. This last shipment or these last 2 shipments is different. I'll call Acme. Acme sends a man out, Mr. Pollock. Mr. Pollock meets back and forth, and I think there's a fundamental question which is very important. I've sued both of them because I have a contract, I think, with somebody, but there seems to be a bit of a dispute between these 2 parties as who's responsible for what.
Well, but you say that, well, let me ask you this. Is it the individuals, your individual clients, that have the contract with Lee Masonry?
My individual clients or Billy Hughes, and
So not the construction company has the...
Well, I sued on behalf of the construction company too.
Yes, so I'm trying to find, who do you say the contract is between?
I think it's with the individuals, Mr. and Mrs. Hughes.
So the individuals and which entity, which other entity?
I'm sorry, sir, I apologize.
So who's on the other side of the contract?
Well, it's a simple purchase at Lee Masonry.
Okay.
We signed nothing with Acme ahead of time.
Okay, so it's a contract to supply the Monte Vista brick between the Hugheses individually and Lee.
That's correct.
Okay.
Ordered by Mr. Hughes, who was actually the contractor who pulled the permit, who was building the house.
Okay.
That's why I sued for all 3 of those entities, Mr. and Mrs. Hughes and that contractor. Yeah. So I guess what I wanted to say is there's no dispute that the brick comes in and everyone can see an appearance difference. Not that it just didn't look right, it's not what we ordered, but there was what was delivered at one point looks differently than the next. So what are we going to do? So this is the part that's somewhat difficult for me to fathom on how to handle it otherwise. But the brick company says, we're not responsible. We're not going to cure anything. We're not going to do anything about it. We're going to call Acme Brick. All of that is cited in the record. Acme Brick sends Mr. Pollock, and Lee Masonry never changes that position. They call Mr. Pollock. Mr. Pollock comes, and Mr. Pollock says, I can see the problem. They talk about a lot of things over a period of time. I think a bit of that minutia is immaterial to the issue. That Acme will say to you, we have all sorts of defenses. Use constitutes acceptance. You didn't report it soon enough because we've got a brick card out there. they will tell you that they have to do this or don't have to do that, and they'll say that Mr. Pollock was going to offer a cure. Well, Mr. Pollock will tell you he never really told anybody what exactly he was going to do, that we're going to pay to do this or do that. Mr. Hughes is sitting there on the horns of a dilemma. Who's committing to do what? Mr. Hughes testifies that he was concerned about the cure they were offering because it would change the quality of the brick, it would change the warranty, and again, he's a contractor, he knows this. It would change the warranty, it would change the appearance, and it would change the suitability of the brick to last over time if they did certain kinds of things. Also, coloring isn't warranted like the brick was to remain that same color for the same lifetime. He never got anything in writing. And if you look and drill down on these facts, you'll see very clearly that Acme Boot never says, this is what we'll do. Now, there's a little bit of a sanction issue, which I'll talk about in a minute, but hopefully very briefly. But I was trying to find out who really has the authority to offer a cure, because we have this oral dispute about what Mr. Pollock was offering and what Mr. Hughes was hearing and who was going to do what when and how it would affect a warranty.
Well, but is there any factual dispute here that the Hughes then sandblasted the brick? I mean, is
No.
there? Okay.
Though ultimately they chose a path.
And that path, it sounds like everybody agrees that that's irrevocable, that once you do that, there's, staining, brick staining is out of the question, is that?
I don't think that's quite true, but I do think it's irrevocable.
Okay.
I think you could still probably stain it again if you wanted to change the colors. But what you have is you have brick that looks remarkably different than other brick on the house. So to get them to match, he did do some pressure washing across the board, which in fact was actually discussed as a potential option at one point by Acme Boot. But they said, let's try coloring first. I'm not here to quibble that there was a lot of discussion.
Yeah, I said sandblasting, but it was pressure washing.
Pressure washing.
Okay.
Yeah, to take some of the sand off, because remember, this is supposedly brick that has more sand on it when it's put in place than the other Monte Vista brick that's already on the house. So this removes some of the sand and gets you back down to that. So Mr. and Ms. Hughes, I guess I'm just saying to you, I want to make sure that you know that there was a lot of discussion about what would work and what wouldn't work. And at some point, and it's clearly in the record, Mr. Hughes is told, Lee Masonry is doing nothing. That's between you and Acme. And Acme is saying, well, we're recommending this colorization and we're prepared to pay for it. But the only person Mr. Hughes ever dealt with from Acme is Mr. Pollock. It's all oral. And Mr. Pollock, knowing that there was litigation, picked up all of his notes, looked at them, made a summary, and destroyed them. No dispute. That's a part of the spoliation of evidence argument that's in here. So, Mr. Pollock
But those notes would have necessarily been all about the cure, correct?
Yes. That's
So,
correct.
I mean, I'm not sure how that really adversely impacts your case. I don't follow.
It's interesting because I don't think it does too, but I think the argument is being made by Acme that it impacts our case because that's our offer to cure. Mr. Pollock made the offer to cure. No one else did. No one else made it, so it's just, what did Mr. Pollock tell us? Did he tell us he was going to pay for it? Did he tell us how it would handle the warranty? Did he tell us what would happen after that?
One of the arguments you made here is that the court, sua sponte, granted summary judgment in favor
Yes.
of Lee when Lee moved for partial, Acme moved for full summary judgment. But as I read the briefs, and maybe I'm confused by this, it sounds like Acme basically said neither Lee nor Acme was given an opportunity to cure in their motion for summary judgment. Did I read that incorrectly?
I don't know that you read it incorrectly, but I think it's a red herring to say that because here's the point. Lee Masonry announced in every way, in every capacity, we have no intention of correcting anything. Nothing. We're not going to take any effort. Acme was the only one who discussed, in part, options for how it could be corrected, colorization or whatever the technique was. nothing in writing. And you know from a review of the file that when I was taking discovery, I was trying to find out who at Acme has the authority to enter into a contract that will, once you do this, this is what we will do to cure it, and this is what your obligations will be. It's an illusory argument to say, well, we offered to colorize it. We didn't tell you we would pay for it. And by the way, we're not telling you that that voids your warranty. And by the way, we're not telling you what happens if we colorize it and it fades over time. We got it. We ordered a product. We had that product coming to us. And at that particular point, we had to do something to move forward. And Acme was offering only one solution with nothing in writing. And it was important for me to learn in discovery that the corporate officers, Mr. Dudney, I think was his name, said, if we had approved a cure plan, it would have been in writing.
Okay. So, and you're out of time. And
I'm so sorry.
But let me just ask this question, and I want to make sure that I understand. The options here, so the brick went up, the 2 runs of brick went up for the house. So they're up. And the Hughes has noticed this problem. The offer to resolve the issue, the Hughes' option was, let's pressure wash it and see if it helps the colorization. There was the staining, which seems to be Acme's, and then was sandblasting another option?
I think that was probably used synonymously with pressure washing.
Okay, thank you. Okay.
I think so. That was a removal of the sand.
So it was just
coating.
an A and B option here.
I think so.
All right, thank you.
And I am out of time, but I want to address the economic loss doctrine, and I want to address, I've got 5 more minutes, I'll wait.
All right, thank you, Mr. Harvey. Good morning, sir.
Good morning, Your Honor. William Scales on behalf of the Applee Cross Appellant Acme Building Brands, Inc., Acme Brick Company. I will take 10 minutes, and my co-counsel, Owen Lipson, will take 5 minutes.
Very good. 10 minutes. Thank you, sir.
This court should affirm the trial court's grant of summary judgment with respect to failure to provide a reasonable opportunity to cure, with respect to denying the deposition-related sanctions, and with the imposition of spoliation-related sanctions. Conversely, this court should reverse the trial court's denial to Acme of summary judgment on the plaintiff's breach of contract claim, their breach of warranty claim, and their economic loss doctrine claim. And I'll start with the privity of contract arguments first. In paragraph 9 of the Hughes' complaint, they assert there is a contract for the sale of these goods between Acme and the Hughes'. Now, as this court's aware, the elements for breach of contract are an enforceable contract, non-compliance that amounts to breach, and then some damages. Here, they cannot prove an enforceable contract, and the record makes that clear. In the record, you see there is a transaction between Acme, the manufacturer, and Lee Masonry, the distributor. There's a sale there. And there's a separate set of invoices for the transaction between Lee, and the invoices say Hughes, but Hughes is a sole proprietorship, so it's essentially Mr. Hughes himself.
So is it Acme's position that the contract was between Lee and Hughes Construction? Okay.
Yes, sir.
So
Yes, sir.
there's even a factual dispute about who the contracting parties are.
I don't know if there's a factual dispute, Your Honor. I think Acme's position is we just weren't part of the contract, whether it's the Hughes individually or just the entity.
So let's, if you can, let's focus first on the grounds that the court did rely on to grant
Sure.
your client summary judgment.
Sure, I can
this
do that.
opportunity to cure. Is there somewhere in the record I can look to that tells me that what the Hughes' did here, the pressure washing, prevented any other avenue of relief?
That's a fair question, Your Honor, and I have to be honest with you, it doesn't necessarily preclude another avenue of relief. I mean, there could be color staining after, but as the papers note, there was streaking caused by the pressure washing. All the sand is gone. I want to take a step back and talk about the nature of this brick, this Monte Vista brick. So Monte Vista brick is just a modular brick, but the color coating, the aesthetic appeal, comes from the sand coating. And so when you remove that sand coating, you're essentially taking away what makes it Monte Vista brick. The issue with this shipment, I'm sorry.
Okay, and I'm
Sure,
sorry, and that's in the record that we can look to the summary judgment papers and that'll explain to us why, because look in the briefs, I didn't get that, that the pressure washing had such a dire impact here.
So again, like I said, the pressure washing just removes completely the sand coating.
Right.
I think you see that in Billy Hughes' notes. You see that in everybody's deposition testimony. The sand coating is what makes this brick
The Monte Vista special, okay.
And the alleged defect in this case is the aesthetic appeal of the brick. And so when you remove what makes the brick, you then expand whatever Acme must do to repair the aesthetic appeal. We were offering this staining process where you stain the brick to make it look like the rest of the Monte Vista brick. But we weren't given an opportunity to do that because, as you know, this pressure washing activity. I think it's important for the court to review Billy Hughes's project notes. And that's in the record, volume 5, pages 664 and 665. I'll begin with paragraph 17 of that document, which is on page 665. And it notes on May 17, 2018, that the parties had agreed that there was going to be this color staining process. And before that could occur, there had to be some cleaning of the brick because of its condition. It was dirty, there was mortar on it, it was dirty. Paragraph 18 shows that Acme said, we're not going to pay solely for the cleaning. We're going to pay for the
Color staining,
but not the cleaning.
Yeah, the cleaning's the contractor's responsibility.
Because Acme wasn't involved in installing the brick
And
and maintaining the construction site.
And
Yes,
counsel,
Your Honor.
the notes that you just cited to me, these are notes of Hughes Construction?
Yes, sir, Your
Okay.
Honor. Yes, sir. And then,
Yeah,
I'm sorry.
I'm sorry, Mr. Hughes.
Yes, sir.
Yeah, thank you.
And so while Acme is awaiting confirmation from the Hughes that they've engaged in this cleaning process, the Hugheses abandon the color staining process that they'd agreed to and then decide we're going to roll the dice on this pressure washing. And they pressure wash all the sand from the rear of the house. They say, we like that, and we're going to do that instead of what we agreed to do. At that point, they've now foreclosed Acme's opportunity to cure, or if nothing more, greatly expanded what's required to achieve color correcting and make them all uniform. And so that's where we argue there's not been a reasonable opportunity to cure because they took our opportunity away. I think it's important there too, if you look at one of the cases they cite, which is that Bennett versus CMH Homes case, I believe it's the name of the case. Yes, CMH Homes, that involved a manufactured home, mobile home, where the Bennetts invited the manufacturer to come out several times to make repairs. And several times the manufacturer came out to make repairs, but was unsuccessful each time. What's different between the two cases, at no point did the Bennetts modify the structure of the mobile home. The Hugheses modified the aesthetic appeal, the key defect they're talking about in this case. So that's a distinction whereby reasonable opportunity to cure must be required. You want to give me further questions on the reasonable opportunity to cure?
Just this, so you move for full summary judgment in the case
That's
on
correct, Your
multiple grounds,
Yes,
one
Your
of
Honor.
being no reasonable opportunity to cure. Did that argument include Lee as part of it, or was it just Acme wasn't given a reasonable?
The heading in the summary judgment motion says defendants.
Defendants, okay.
Returning to the breach of contract claim, in addition to the invoices not being between Acme and the Hugheses, Mr. Hughes admits he had no contract with Acme. He admits that the contract was with Lee. There are no invoices, checks, or receipts between Hughes and Acme. Mr. Hughes admits that he doesn't recall executing a contract with Acme. He said he never received any type of contract with Acme. And what's also very important is during the purchasing process, at no point did Mr. Hughes or Ms. Hughes speak with an Acme representative. The first time they were talked to an Acme representative was once the brick had been installed. So Acme can't be part of the sale process. They're merely the manufacturer. Because there is no privity of contract between Acme and the Hugheses, Tennessee law bars the Hugheses from recovering for implied warranties. To overcome this hurdle, the Hugheses rely on Tennessee Code Section 29-34-104, which describes instances in which privity is not required for recovery. What's important to note about that statute is that it focuses on personal injury or property damage. As we've noted before, this is solely an aesthetic defect. There was no personal injury and there was no property damage. So 29-34-104 does not rescue their claims. Turning to the economic loss doctrine, if you look at the damages that the Hugheses want to recover in this case, they are the cost of the material and labor, which is cost to repair, and alleged diminution in value of the home in the marketplace, which is essentially lost profits. Both of those items, Tennessee case law explicitly says are economic loss and cannot be recovered without a contract. So unless this court agrees with the trial court that there was a contract or dispute fact about a contract, the economic loss doctrine bars their claim. And in my final minute, I want to speak briefly about the sanctions requests. And I'll note just this one thing. The standard here is that the sanctions determination will only be set aside on appeal when the trial court has misconstrued or misapplied the controlling legal principles or has acted inconsistent with the substantial weight of evidence. I think our papers demonstrate that neither of those things occurred here.
And there was some sanction, was there not? It was like $1,000.
Yes, Your Honor. With respect to the spoliation, there was a $1,000 sanction. The court said people cannot destroy notes, and I understood that.
Are you asking us to reverse that?
No, Your Honor.
Okay. Let me ask you, I know your time's up, but I want to ask you one other question. The tags that come on the bricks when they arrive, is that an Acme tag, or is that the one that says
Use constitutes acceptance?
Yeah.
That's an Acme tag. It comes on all the brick. And the purpose of that is described, before you use this brick, if there's an issue, give us a call. Because as the UCC notes, and as you know, if you use it, then you've accepted it. And so that affects some of your remedies.
Yep.
Any other questions, Your Honors?
Thank you, Mr. Scales. Good morning.
Good morning, Your Honors. I'm Owen Lipscomb. I represent Lee Masonry here in this case. The first thing I would like to address is what I perceive to be a mischaracterization of Lee's role in this cure process. It's been argued this morning and in brief that Lee was not involved, that it just rejected responsibility out of hand. That is far from the case, and if the court will follow me on this, assume that you purchase a car, a General Motors car today, and you order it specific, and it arrives, and it's the color that you didn't want. You're going to go to the dealer, and that dealer is then going to go to General Motors to get it corrected. That's what a distributor does. In this case, Lee is the distributor. Lee, in fact, did that. They got brick that was delivered to the Hughes. The Hughes were not satisfied with the result. Lee, Mr. Sanders, picked up the phone and called Acme and got Acme involved. Throughout the process, Mr. Sanders is involved. He's setting up appointments. He's appearing at the Hughes house with the Acme representative. They are all working on it together. No, they are not actually doing the scraping, but they are part of the cure process. And in fact, it is Mr. Hughes' argument that it was a final call from Mr. Sanders that made him conclude that this couldn't get worked out. That's in his own admission. That's his brief. So for him to say that Lee was not involved in the cure process is just not accurate.
And who does Lee say the agreement was with? Who are they contracting with?
They're with us. I mean, they bought the brick from us.
But Hughes, oh, I've got three options here.
I know where you're going.
Yeah,
It was Hughes Construction, Your Honor.
okay.
And the reason I say that is Hughes, the testimony from Mr. Hughes was, I purchased it through Hughes Construction because I already had an account with him.
Okay.
This was a commercial account that he would use to buy brick, to buy homes. His contract, it was Hughes Construction who purchased the brick, not the individual. With regard to the motion itself, I am tied to the hip with Acme. If the court decides that Acme's motion should fail, I go down with it. But if it's upheld, and we're asking the court to do so, then the next question is, should the judge have granted my client, sua sponte, the motion? And our position is, yes, in this case, it makes sense that she did so, and it is appropriate that she did so. We did raise the duty to cure and the failure to adhere to that as an affirmative defense in our answer. The issue was briefed at length by Mr. Hughes at the trial level. Going back to the court's question to Mr. Scales, their brief did include my client Lee as part of the motion. It was both of us. And therefore, Hughes was, throughout its brief, addressed the actions of both Acme and Lee throughout, argued at length throughout what Lee did, what Lee didn't do. It was all in there as part of the motion for summary judgment process. We feel, if you look at the case law, first of all, we all agree that a trial court can grant a motion for summary judgment sua sponte, but it's rare.
Yeah, and it should be rare, and that's what's concerning. Whenever I see in a brief or a sua sponte grant, I'm thinking, okay, we've got trouble here.
Absolutely, and the case law is clear. It's got to be rare.
Doesn't that normally occur when, let's say, a plaintiff files for a motion for summary judgment against a defendant? Everybody agrees the facts are not in dispute. The court decides, well, this motion shouldn't be granted, and as a matter of fact, the defendant should be dismissed from this case. So isn't it usually in that context that it's sua sponte?
Judge, I can't say I read every case on the issue, but I believe I read the main ones, the majority, and I cite the court to the Patton versus Estate of Upchurch and the Nashboro Village case that I attached to our brief. That was not the case. These were defense motions.
Well, it doesn't have to be plaintiff or defendant, but
Yes.
It's usually where the court says you're not entitled to summary judgment, but the other side is because the facts are undisputed and you've cited the law and
Yes, sir.
what have you.
And I think the issue in all the cases, and there are cases where the appellate court has said, no, you shouldn't have granted it. Forgive me, but the issue is, was there a full and fair opportunity for the non-movement to address the issue? And it was in this case, absolutely.
Thank you, Mr. Lipscomb. We'll hear rebuttal from Mr. Harvey.
Let me take up the last point first. I'm reminded of one time when I was in front of a judge and he said, well, we don't have to worry about what you say was said, we can go read it. So we can go read that motion for summary judgment, and once you get enough gray hair, you remember that Me Too motion that people can file. Mr. Lipscomb didn't file a motion. And if you want to talk about what's surprise, the look on my face was total surprise when I got that in, because Lee Brick's Chris Sanders testified that Lee Brick was simply a distributor of the brick, and any resolution of the defect issue would be between Acme and Hughes. He testified further, any solution to correct a defect in the brick is the responsibility of Acme, not Lee Brick. That's all cited in the record. The motion by Acme was that we offered a cure. And all of this argument that you've been hearing sounds a lot like we're arguing weight of the evidence, but we're not. We're talking about a summary judgment motion. And all of these facts are in dispute.
Well, but what's not in dispute is you have pallets of bricks showing up that have tags on them that say, you know, you put these bricks up, you bought them. And that happened. And there's no dispute about that.
There is none.
So, I mean,
I'm-
why is it that crossing the Rubicon in a case like this? Why does your client get to say, well, I don't care what the tag said on the bricks. I don't care that I could have said, nope, right now on the pallet, these bricks don't look like what I thought they did. We need to send them back and get this straightened out first. I mean, why isn't it too late after that?
Because now at this point, we've called Lee, and Lee's called Acme, and Acme, if you just go directly to your point, Acme says, well, look at that tag there, you've already put them up. So I guess I do have a contract with Acme. I do have an agreement with Acme. You know, so, and if I do, then my proof would be for a trier of fact to hear that Acme came and showed up and said, well, let's talk about what we'll do. In here, you'll see Mr. Pollock says, we're a company, we've been around a long time, we're going to try to make this right, let's talk about solutions. So I guess if I go to Lowe's and buy a Whirlpool that has a Whirlpool tag on it and a Whirlpool advertisement and a Whirlpool tag that comes with it says, here's your warranty, then I have a contract with Whirlpool. I had a contract with Acme. I don't want to miss the point that this is summary judgment. And I actually said to the judge in summary judgment, all of these arguments, I may go down at trial because the trier of fact may find this person's in contract with me or this person isn't. But these are all just disputed facts. And I set out for the judge, when the judge says, you know, we got this little issue about the order coming down. She writes a memorandum opinion and then we get a second order. Memorandum opinion says you're missing all these facts. I can tell you that we have disputed facts set out in specific additional undisputed facts that we sent that are clearly disputed that go to the question of is there an offer? Is there not an offer to cure? In regard to one of your questions, the sequence is important. Mr. Hughes is trying to get a cure. He does not believe the colorization is an appropriate cure. The colorization is all they have offered, and it's not in writing. And Mr. Hughes is saying, I don't know what I'll have. I won't have a brick that has the same warranty if they do the colorization. I will not have the same quality of brick. All those are disputed facts from a contractor who's building this house. And so those disputed facts go to a jury and a trier of fact at some point. On the economic loss doctrine, I think we're pretty clear on, at least as it applies to this case. The economic loss doctrine would bar the recovery under a products liability theory if I don't have a contract. But I've got disputed facts as to who the contracting party is here. They're both going to say, I'm not responsible for the warranty, I'm not responsible for the contract, and the right to cure, Mr. Lipscomb could have said, and the motion to dismiss says what it says. It was filed on behalf of Acme Boot. I was not required to say Lee is not going to be dismissed by this motion. It was filed by counsel for Acme Boot when there was Acme Brick, counsel for Acme Brick when Lee Masonry had counsel who was there at the summary judgment hearing.
Right, so, but whoever the contract was with, and I appreciate there's some dispute about that, at the end of the day, bricks showed up at the Hughes property with labels on them that said, you put these up, they're your bricks, and they got put up. I mean.
They did.
Yeah.
They absolutely did, and they were non-conforming. And so when Mr. Pollock shows up, and Mr. Pollock says, and this is cited in the record, I mean, I can't fumble through pages and suggest all that to you, but we cited it very carefully. There are 106 additional facts that I put in here in opposition. Mr. Pollock was deposed, and Mr. Pollock says, I was there and told him we want to try to figure out something we'll do. I had something that I was preparing Acme to get ready to approve. But it had been 6 months. It had been a period of time, and in fact, as Mr. Lipscomb said, Lee Masonary's representative Sanders had said, I don't think Acme's going to do anything else. So it was up to Mr. Hughes to try to mitigate his damage as best he could. And we're at the summary judgment level. We are not trying this case on these facts, and these two defendants should both be there, because if the Acme Brick Company is removed from this suit, then Mr. Lipscomb's going to say they were responsible for the warranty, not us.
All right, thank you all for your arguments. We'll take this matter under advisement. That concludes the morning